media in 2015, like probably many of you, I had certain preconceptions about the country. Spicy foods, rainy season, Bollywood. Unfortunately, I also knew its capital, Delhi, by what international media headlines were calling the rape capital of the world. Now, presumably there are several ways that one might try to account for this unsavory moniker. Sensationalist media, racist and imperialist Western journalists, fake news. But in my first visit to a police station, early on researching police investigations into sex crimes, the deputy head of the station told me that the reason for this alarming statistic on rape was actually false complaints by victims. Now, as a law student, I'm not a stranger to the historical legal presumption that women are prone to making false complaints. It's more believable that a woman would have lied than have actually experienced sexual assault. And so I asked the director, how do the police know that these cases are false? And he assured me that after years of policing, they developed this sixth sense that enables them to tell as soon as a woman walks through the door. A visual lie detector test, so to speak. Now, what the police officers described to me that day were actually the telltale signs of the real rape scenario. And I'm sure you're familiar with it. The real rape is that one-off violent attack by a stranger where the woman strenuously resists to the point of suffering visible signs of injury. It's a narrative of pop culture, film, and media, not actual survivors. Essentially, what the police officer described to me that day is that his well-honed sixth sense identified as real victims only those who conform to this ideal type. Unless she walked into the station showing the symptoms that we see in the movies, so far as he was concerned, she was just faking it. Now, the ideal rape victim is not a static figure. She is a product of her time and of her place. Indian cases show us that she's likely to be Hindu, and also chaste, young, and naive. In Australia, feminists such as Professor Wendy Larkham predict that successful rape complainants are likely to be young, able-bodied, non-Indigenous English-speaking women. Interestingly, it no longer assists the case for the prosecution to show signs of injury on the victim. In our post-50 Shades of Grey culture, women with injuries in rape trials are women who consented to rough sex. Now, this narrative of the ideal rape victim can be hugely problematic, where it normalizes the idea that rape is only real and only harmful for certain people in certain circumstances. Now, while the very high-profile and very gruesome rape of a young girl in a bus in Delhi in 2012 was the catalyst for major law reform, it also created a new ideal rape victim standard. In this case, a young girl suffered horrific torture and gang rape at the hands of a group of strangers, and she died as a result of her injuries and outraged a nation. But the outcome of this was that it raised the bar to all other survivors of rape to earn the sympathy of the general public. For when rape leaves no physical scars, but is of someone's bodily autonomy and their trust by someone they know and in their home, how can it be harmful enough to measure up to the trauma of rape as we imagine it? And so when I brought up the idea of this ideal rape victim to the deputy, and I queried whether this sixth sense of his was in fact a result of myths and stereotypes, he told me that this wasn't the case. The women in India were more likely to lie about rape. And as proof of this grand assertion, I was referred to the low conviction rates in cases called rape by false promise of marriage. Now, in order to understand these cases, you need to understand the specific cultural context. In many parts of India, there is still a huge stigma around sex outside of marriage. And a woman losing her virginity also risks losing her marriageability and her family's honor. And so to protect these vulnerable women and their families from extreme social consequences, the courts have made it a crime for people to intentionally lie about their intention to marry someone to get sex, when otherwise she would have said no. And the deputy is right. These cases are characterized by extremely low conviction rates. But why is this? Is it because, as he told me, women are making false complaints of rape? Or rather, is there something else? Now, after reading hundreds of cases of this type, what I learned is that most cases which result in a not guilty verdict are because the woman denies the prosecution's case at trial. Often, there is also evidence that she and the accused have been married. And now these cases often read like a script, recording that she denies ever having reported rape to the police, she denies ever having been raped under a false promise of marriage, and she denies that she is now testifying falsely as the accused has married her. And so at face value, what we see is a wrongful complaint against an innocent accused, and the police, the judge, and the media then condemn these women as liars. An allegation of rape becomes a weapon in the hands of a woman deployed to coerce an accused to marry her, which can then be retracted, ending the shame of investigation, the risk of trial, and possible imprisonment. And so at face value, this is one possible reading of these cases. But when we look at the specific cultural context, and we start with the assumption that not all women lie, what we see is that changing your testimony and a legitimate complaint of rape are not mutually exclusive. In fact, while it's illegal in cases of rape, defense lawyers and prosecutors will tell you that compromise and out-of-court settlements are incredibly common in India. And now sometimes this compromise is a tool for defense lawyers, a tool to pressure a woman to change her testimony with threats and coercion behind the scenes of the trial. And sometimes this compromise takes the form of an offer of marriage. And for us, using marriage to settle the wrong of rape, it goes against feminist theory, and it confirms that rape is not criminalized to protect an individual woman's autonomy, but rather protect a father from the loss of his daughter's value as a transferable asset, a value which is attached to her status as a virgin. But the practical reality is in that many poor communities in India, where the only other option is life as a stigmatized social outcast, a marriage to the man who robbed her of her virginity is preferable to both her and to the accused than his possible imprisonment. So the belief in India that women are making false accusations of rape is also complicated by the fact that the courts are prepared to prosecute men who lie about their intention to marry, a radical departure from that violent rape narrative. And in this respect, Indian law takes a broad view that frauds like this will destroy consent, a view that reflects the very real harm that women in this situation face. And this contrasts with the position in Australia and in the UK, where courts have resisted expanding the scope of rape to encompass those cases where consent is obtained by fraud or half-truths. Now, the foundations for our current understanding of when fraud will vitiate consent comes from an English decision in 1888. Now, in this case, the victim's husband was charged with assault for having intentionally infected her with gonorrhea, in a situation where she would not have consented to sexual intercourse if she'd have known. And the court said, that doesn't matter. So long as our consent is made with full knowledge of the sexual nature of the act, the reasons why we give it and the conditions upon which we exercise it are not significant enough to invalidate that consent. And now this extremely narrow understanding of consent means that cases where fraud will infect consent are scarce. And the exceptions that we do have are very much the result of public outcry in response to high-profile decisions where we feel that the law has got it wrong. In the 1860s, for example, a bizarre phenomenon was sweeping England where midnight interlopers were sneaking into women's rooms and pretending to be their husbands, initiating sex. And the court said, this isn't rape. But the legislature intervened and they criminalized these cases of spousal impersonation. In Australia in 1957, the High Court considered the case of a religious Greek migrant who was tricked into believing that she and the accused were married. And after giving her consent on what she believed to be their honeymoon, he took off, robbing her of her virginity and of her prospects in this new country. And the court again said, her consent is still valid, but parliaments in Australia have expanded the scope of rape to protect people from precisely this lie. Now, some have advocated for the criminalization of all deception, but it is easy to imagine cases where this would lead to injustice. For example, in 2016, the New South Wales Parliament decided against criminalising half-truths, such as, "I love you," or "I'm single," or "I'm not seeing anyone else," which could realistically affect our decision to consent, but which perhaps aren't always told for exploitative reasons and might not have that same harm. And so what these examples show us is that the line between sex and rape isn't static, and it is certainly not solely determined by individual choice. Rather, what we have is this middle ground that defies definition, which is informed by personal and cultural values, power imbalances, and harm. And as these values shift and change, so does the scope of the law's protection. Now, as someone who's not religious, and as someone who won't be stigmatized by sex outside of marriage, my biggest concern when it comes to deceptive sex is not that someone's going to sneak through my window and pretend to be my husband, nor is it that I'm going to be tricked into giving my consent under a false promise of marriage. Rather, what I'm afraid of is what college boys call stealthing, where I agree to consent with the condom and he intentionally and secretly removes it, exposing me to the risk of STDs, unwanted pregnancy, and privileging his whims over my consent. What I'm afraid of is that someone will secretly upload videos of me having sex with them online without my consent, like what happened to the young Australian Defence Force cadet who was unknowingly live-streamed to a group of boys in the neighbouring dormitory. But as it stands, the scope of my consent does not depend on those conditions. While public outcry has forced the legislature to criminalise the non-consensual uploading of intimate images, the line between rape and sex hasn't changed. Rather, Parliament has decided that these lies should be captured by enacting discrete, specific offences and not by requiring a more informed consent. And now the problem with this is that the people who will be protected are people who look like me and people whose interests are like mine. And we'll end up with this new but equally narrow narrative that excludes those whose harms don't look like that of the mainstream. Now, on my last visit to the police station in India, a woman walked in nursing her tiny baby. She was crying and she was tugging at the police officer's sleeve. And I later asked the deputy what had her complaint been about. And he told me not to worry. She was one of those false complainants. She'd complained that her husband had raped her. And this couldn't be true, as in India, husbands don't rape their wives. Now, this blunt assumption is legally warranted, as the Indian Penal Code still contains an immunity for husbands who rape their wives, an immunity that was inherited from the English common law and which we maintained here in Australia until the 1990s. And while after the Delhi attack, the legislature increased the penalties for rape, they affirmed that the removal of the immunity was unsuited for India. For how could it be harmful? How could it be immoral if it wasn't a stranger using violence, but a husband asserting his conjugal right? Now, what these stories that I've told today have in common is that they show us that the line that we draw between sex and rape traces the contours of an ideal rape victim. And the narratives we construct around real rape determine not only who is believed, but also the scope of a valid consent. A consent that doesn't have to be informed, and a consent that is incapable of capturing those personal and cultural values, the power imbalances, and the consequential harm which characterize the gross violations of truth, bodily autonomy, and psychological manipulations which warrant the label of rape. Now, I'm afraid I won't be ending today with an uplifting conclusion or an answer for the future. Greater minds than mine have tried and failed to draw a bright line through the murky waters that make up this contested space. Rather, I hope to have convinced you that the law in this area is severely unjust, and to have left you with an important question at the forefront of your minds. When sex means so many different things to so many different people, how do we determine the limits of rape? Thank you.